And we're going to give folks a few minutes to continue to log in.
Living in a movie, we can make a call. Oh, I can read your lips, and every time I fall, I wanna hold you closer and look into your eyes. Remind me of the kiss we shared that summer night. Living in a movie, we can make a call. Oh, I can read your lips, and every time I fall, I wanna hold you closer and look into your eyes. Remind me of the kiss we shared that summer night. I wanna feel your heart, I wanna feel the beat. Anything for your love, I'd cross the 70s. When we're oceans apart, no, I will never leave. And even when it's dark, I'll give you all you need. Living in a movie, we can make a call. Oh, I can read your lips, and every time I fall, I wanna hold you closer and look into your eyes. Remind me of the kiss we shared that summer night. Watching all the stars, they're falling in the deep. I'll keep you in my arms until we fall asleep. Can never get enough, it's a mystery to me. And we'll be sunset lovers, with you I wanna be. Living in a movie, we can make a call. Oh, I can read your lips, and every time I fall, I wanna hold you closer and look into your eyes. Remind me of the kiss we shared that summer night. Living in a movie, we can make a call. Oh, I can read your lips, and every time I fall, I wanna hold you closer and look into your eyes. Remind me of the kiss we shared that summer night.
Good morning, everyone. Can you hear me? Okay. Hi, I'm Maria Bostic at the West Family Justice Center, and I am a bilingual navigator here, and just want to welcome you all. Glad you can join us today for a wonderful presentation on tenant rights, and we hope that you take a lot of good stuff with you. So I just want to give you a little background. Family Justice Institute is a program of the Family Justice Center. We've been able to bring free and excellent workshops thanks to our local experts. Family Justice Center is a one-stop center for IPV victims and their families. Excuse me, I thought I turned it off. The music wants to keep playing. Okay, can you hear me? You can still hear me? Okay, so the music's off. Sorry about that. The music wanted to keep playing. Anyway, so we are, like I said, we are a one-stop center for IPV victims and their families. So again, this is just a friendly reminder. Please keep muted as we're going through the presentation. As you know, we are also being recorded. There will be an evaluation that's very important. It'll be at the end of the presentation, and we will also be emailing you after the workshop.
You can still hear the music.
Please make sure to fill it out. We want your input and how to improve the content of our institute.
Maria,
so slides and other materials will be I'm sorry, you can hear me, right? Other materials will be emailed to you and to everyone after the workshop. So we will make sure that the recording of the workshop is also available to you. So I just want to let you know, I will be presenting the presenter, and this will be Alejandra Perez Orozco from Bay Area Legal Aid. And this is the time for all of us to learn together. So without further ado, here's Alejandra.
We still listen to music.
Good morning, all. Thank you for your patience on a Friday. Thank you all for sharing your Friday time with me.
Oh,
We're gonna
I can't get, look, I can't, oh, here it goes.
we're gonna get started. We have a lot to cover. As Monica mentioned, my name is Alejandra, and I am an attorney at Bay Area Legal Aid. Um, Just to go through what you can expect for the presentation today, we're going to go through some tenant protections that we have under local, state, and some under federal law. And then some of the objectives for some additional learning will include that after the workshop, you'll have a better knowledge of what updates to the law have happened. It won't be all of the updates that are relevant to housing, but it'll be sort of some of our hot topics that I think you'll find useful. And then additionally, you're going to learn about some additional resources for tenants that could be helpful in the services that you provide or maybe in your own life. Just going to share a little bit about client eligibility. And before I jump into to everything, I will make a couple of comments. One is that we will share the presentation afterwards. The second is that if you have questions as we go through, please feel free to write them down or save them. We're going to have a space for questions at the end of the presentation. Because I'm here just presenting by myself, I won't be able to monitor the chat, but I'm happy to answer any and all questions you have once we get to the end. And then the last thing I'll say is my presentation slides are going to have lots of writing. It's not to make you read and it's not to confuse you. I'm happy to go through with them as we present. It's mainly just to give you a point of reference later in time if you want to refer back to them to keep you from having to write lots of notes. That being said, so with client eligibility, this is just our eligibility for Bay Area legal aid. We do provide free legal services in our 7 Bay Area counties. In order to be able to do that, we do receive funding that provides certain guidelines around who we can help. Now, we also provide services in a variety of areas that I just want you to see here for your reference. Today, we're going to be focusing on housing, but we certainly have other practice areas within the scope of our services that may be relevant to you or your client's needs if ever you're wondering what additional services we provide. Ways to access our services. This is a really important point. If you want to get in touch with us or you want to direct clients to us or folks to us, they can reach us through our legal advice line for all of the areas that I previously shared in the slide. And our information for the hours and the phone number are here. I do also want to let you know that we have a dedicated line for Contra Costa County that is also listed here. Essentially, if somebody's calling, they can call either one of these lines and they'll be connected to one of our legal advice line attorneys. Having been a legal advice line attorney on our line, I can share a couple of tips with you to help you better access our services. It is important that if you're trying to reach us, you try to reach us as close to 9:30 as you can when the line opens. As the day sort of continues closer to, I would even say noon, we get so many calls that then the line can close. So please be sure to call as close as you can to 9:30. If you're able to, you can leave a message and you'll receive a call back. That's significantly better than having to wait on the line. And additionally, one of the common things I get a lot is that folks are calling us outside of the hours. So if you're calling on a Saturday or an evening, you won't be able to reach us. So just keep that in mind. And let's jump in. We have a lot to cover. Certainly, I don't want to bore you on a Friday, but I want you to have time to process and ask questions. We're going to jump into some of the common hot topics that I hear a lot from folks around things that they need. And one of those hot topics that are really common for folks are security deposits. And I want to let you know about an update in security deposit law that just rolled out back in 2024, where now landlords can only require 1 month's worth of rent for a security deposit. And in this very limited situation, can they charge 2 times the monthly rent for a security deposit? And all these three things have to apply. This is a change from the previous security deposit rules under the state of California, where for furnished units, you could charge up to 2 times the rent, and I'm sorry, for furnished, it could be up to 3 times the rent, and for unfurnished, it could be up to 2 times the rent. So now it's making it a little bit more affordable. We all know that a security deposit can be quite costly. But I think even with these changes in the law, what I see a lot is that if folks don't know about it, they may not be able to understand what their rights are if, let's say, a landlord is trying to charge them more than what the rent requires. So this is an important update, and I flagged it here for you in case you want to refer to it later. Um, Another common issue with security deposits is how do I get my security deposit back? We know that sometimes it can be quite difficult for a number of reasons, but landlords may be withholding deposits for different reasons. And I wanted to sort of cover some basics around how the state requires that your security deposit be treated. The first thing that has to happen is within, well, really, the first thing that happens is you're entitled to a move-out inspection before you leave. And during the move-out inspection, you're supposed to be able to go through the things that would potentially be an issue with your security deposit. But once you move out, the idea is that you would provide your landlord or ownership your forwarding address so that within 21 days, they're required by law to send you a letter that lists exactly how they're going to treat your security deposit, whether they're going to make deductions, what those deductions are, and what amount they're going to return to you. Now, generally speaking, if the deductions are more than $125, as we list here, they have to provide you a copy of receipts and invoices and additionally like good faith estimates of what they're saying will need to be deducted. The most important thing that I want you to understand is that the lawful deductions under state law, the things that they are allowed to deduct from your security deposit at the time of move out, are what the law calls costs for repairs beyond normal wear and tear. And this is a little bit harder to understand because it's not as clear, but essentially, if you've been living in a place for 10 years, whatever normal wear and tear happens over the course of 10 years is not something that would need to come out of your security deposit, but it's beyond, if it's beyond the normal wear and tear that would happen during 10 years, then they could potentially deduct it. This also includes any unpaid rent that has accumulated at the time of move out and any reasonable cleaning fees. And importantly, and I don't see this on this information, but if, let's say, the landlord doesn't provide you anything within 21 days, and you did provide them with a forwarding address, but you didn't receive a letter within 21 days of move out, then they waive their claim to any deductions, even if they're lawful. Now, when there's a dispute, let's say your landlord doesn't return the amount that you believe you're entitled to under state law, there's a couple of things that tenants can do. The first is I always recommend that they send a letter basically saying, look, I don't agree with the amount that you're returning to me. Please return this amount based under my rights under state law. If that doesn't work, and sometimes it doesn't, we know that tenants can file small claims court actions to recover their security deposit. And just very briefly, small claims court allows people to sue for costs, let's say, that are at least in our county in Contra Costa up to $12,500. And there's no requirement that a landlord represent either party. In fact, attorneys are not allowed to represent you when you start your claim. And it's designed to be sort of more accessible for resolving issues like, for example, a security deposit. Now, another hot topic that we get a lot of questions about, and I'm sure in your scope of work that you do with folks, you probably hear a lot about repair issues. Under state law, we call these habitability issues. And really, what's important to understand is, I think this slide skipped. Yes, it did. What does that mean? It generally just means that a landlord has a duty under state law to provide you with a unit that's safe for human occupation when they're renting to you. And that generally means they have to comply with a bunch of laws, both local laws and state laws, around what that is. Generally speaking, I can tell you that it means that there are certain elements of your unit that have to be what the law says in good working order, like electricity, gas, like structural issues. They all have to be in good working order so that it's safe for you to live there. But the law also requires that in order for a landlord to have an obligation to make these repairs, they have knowledge that there is a problem. So it's very important that under these legal requirements, a tenant provide notice to their landlord that there is uh, a repair issue that needs to be addressed. Now, I am hearing some background noise from folks who have not muted. If you have not muted, I just please ask that you mute. Um, Now, what do we generally recommend in terms of what tenants can do? Because repair issues are really quite common and they can affect people in a variety of different ways. There's a number of things that we generally recommend. The most obvious thing for me in seeing these issues day in and day out is it's important that tenants provide notice in writing to their landlords as soon as the problem happens, and then to keep records like photos, videos of issues as time goes on, because it is the landlord's obligation to make repairs within a reasonable amount of time, or with certain categories of repairs that are an emergency, as soon as possible. Now, there there are a couple of things to keep in mind that I want to make sure I go through. There's one common question that happens is, what if a tenant has caused the condition, right? Let's say there's a hole in the wall that's affecting the bathroom or something. In those certain situations, the law does recognize that if a tenant has created a problem, then they may be responsible for the costs and repairs. But if there are issues that are happening just sort of in the course of the tenancy because there's wear and tear in the home, then certainly those basic issues that affect habitability need to be repaired by the landlord. When we're talking about strategic things that tenants can do when the landlord does not make repairs, there's a couple of recommendations that we generally have. You can, depending on the city that you live in, and some cities have their own code enforcement department they're charged with basically enforcing the building codes and health and safety codes and issues relating to rules that their particular city or county has adopted. You can call them to perform an inspection on the unit. Now, in some cities, it's a city service, in some cities, it's a county service. But I do want to note that there's a risk involved there, and the risk is that if they come out and they find that the conditions are so bad that it's not safe for human occupation, then they do have the authority to do a couple of things. One is, worst case scenario, they can red tag the unit, which means that they can deem it unsafe for human occupation and ask that you leave the unit almost immediately. That is the risk that comes with calling code enforcement. I do want folks to keep that in mind. The other risky things to do is there are rules within the state of California that allow you to make your own repairs and deduct them from the rent, or there are situations where people withhold the rent as a way to incentivize their landlord into making repairs. Those can be very risky, and we generally don't recommend them. The repair and deduct um, process requires really specific steps and things that are not always as easy as repairing and deducting sounds. And then it puts you in this position where the landlord can say that you haven't paid rent and then start a process to try to evict you based on that non-payment of rent. And then you're sort of having to defend yourself in an eviction process when there are repairs the landlord has not made. So generally, we do recommend is if you live in a city that, for example, has a rent board, you can consider filing a rent petition, and I'll go through what that can mean a little later on in slides. But essentially, it means that your local city has adopted additional protections that allow you to turn to them to file a petition to have basically a reimbursement of the rent that you've paid in excess. The repairs that haven't been made are essentially you're not getting what you're paying for. And they can order repairs to happen through their process. Additionally, you have the option of filing your own suit, essentially saying that they have breached their duties to provide you a safe housing and making repairs. These are all complicated things to talk about because they can be fact specific, right? You may know of situations that require some additional thinking or some additional advice. And certainly with any questions that you have around some of these issues, I recommend that you know local resources well. So for example, if you have a local rent program, if you have a local legal aid organization or resources that you can turn to for specific advice about a particular factual situation. Now, when we're talking about being a tenant and navigating a lot of these issues, we do have some general best practices that we recommend to folks. And I want to just go through some of them with you in case they can be helpful in navigating issues you face with clients or in your own life. Generally speaking, when we're talking about, let's say, renting a place, it's usually based on an agreement, and the state of California requires that both parties engage in good faith and fair dealing. And that also means that parties can't unreasonably interfere with the rights of the other party in trying to, let's say, live in their unit. I want that to be context. Obviously, we know that can be very difficult to enforce, but that is an obligation that exists. It also is important that you inspect the unit before moving in, when you're moving out, and you document it, right? You take photos, you take videos, so that if there's ever any dispute around the condition of the unit, you have something to point to as to really how you received the unit, how you left the unit, and essentially any of the decision making you're going to make in terms of resolving issues that come up. And then communicating. So a lot of the things that come up in issues between, let's say, tenants and landlords can be served by trying to communicate as best as both parties can, especially when you're making any requests. Always advise that you make them in writing so that you have a record of what you're asking for, when you're asking for it, in case it's ever in dispute in the future. And then I don't super enjoy saying this one, but it is something that makes a big difference. To the extent that you're able to, it's great to be able to pay rent on time so you don't face issues around non-payment. And when you pay rent, it's important that you have a record of it, right? So whether you're able to pay in a way that gives you a record, like money order or check, And if for whatever reason you're paying in cash, it is important that you do your best to obtain a receipt. So there's a clear record that you're paying rent and that you're paying timely rent if ever again a dispute comes up. Now, I want to move into some additional protections under state law that we call kind of in two categories, so rent control and just cause. And what does that mean? Well, I can tell you that the state of California adopted statewide protections for a number of tenancies, let's say places that folks rent that are covered by these protections. And as I said, it's two categories. The first, which is rent control, limits the amount of rent that a landlord can let's say it a different way, limits the amount that your rent can be raised periodically, right? So it basically sets a cap on how much your rent can be increased. And for covered units, the landlord can't raise the rent more than, and this is the state rule, a 10% total or 5% plus the percentage of the change of cost of living, whichever is lower. And that can vary by county and in certain cases, some cities on how it's calculated. But what I did is, in case you have any questions, there's a hyperlink here where it says caps rent increases. That takes us to a fact sheet that covers some of these percentages by counties, including our local counties. So you can see if this rule applies to your rental unit, you can see the maximum percentage that your landlord can raise your rent. And the good takeaway here is that it's not going to be more than 10%. I think in Contra Costa County right now, it's closer to 9%. Now, if the landlord wants to do smaller increases that essentially are combining to get to this total maximum, they can only increase the rent 2 times in 1 year. So really, if they're charging you the maximum increase, which is going to be no more than 10%, you should only be raising your rent once a year. And the key question here then is, well, what units are covered by California rent control? And that's a really good question because there are units, and this is the way that essentially it's listed under state law, that are not covered. And I just want to draw your attention to some of the more common ones. So you're not covered if you live in, you're a mobile home owner. There is a whole separate set of rules that apply to mobile homeowners. And it doesn't apply to units that were built within the last 15 years. There's some other things, like dormitories. There's other types of restricted. So, for example, the third bullet point relates to subsidized housing. And it's, for example, like if it's a public housing type of rental unit space, and that wouldn't be covered by the California rent control protections. However, our Attorney General has sent out a memo indicating that Section 8 housing may be covered and would likely be covered unless it fit under any of these other exceptions. Now, this gets confusing because you really have to look at the facts to understand if a unit is covered. And I'm not here to make you read all of these different exceptions, but I want you to have them in case you have questions about, okay, well, I want to look more closely at these facts. Certainly, I always recommend you seek legal advice for somebody to help you analyze whether a unit is covered. The second category of these protections that we talked about earlier is there's rent control that limits the amount of rent, and then there's just cause. And what does that mean? Just cause means that if your landlord wants to terminate your tenancy or wants to end your lease, they have to have a reason, a just cause, of the reasons permitted under the law. And in this case, state law has set out these two categories of reasons that they would allow the landlord to terminate your tenancy. And it has to be one of these reasons, and one of these reasons has to appear on the notice that you're going to receive. So if you were to receive a notice and you're a tenant who's covered under these protections, and that notice doesn't have any of these reasons, then that notice wouldn't be valid, for example. So you'll see that there's two categories as the law defines it. One is called at fault, which means that you've done something. It could be non-payment of rent, could mean that you've engaged in criminal activity on the premises, or at least under state law, you refuse to sign a new lease that contains similar terms. The other category, and something that may be common as well, is that you're receiving a reason for something that's not your fault. It could be that the owner's saying they want to move back into the property. It could be that they're saying they're going to demolish or substantially remodel the unit. It could be that they're saying they need to comply with the government order. With all of these no fault reasons, there are specific rules that have to be followed. And so if ever, let's say, someone comes to your aid to say, look, I got this notice, there are these things on it, is it the right notice? I just want you to remember that because there are all these rules around what should be on the notice and what's required if they use any of these reasons, that they seek legal advice, right, from someone who's familiar with what should be on there, what are the special rules if some of these reasons are listed. And who is covered by this just cause part of the California protections, right? We talked about who's covered by the rent control part, but the just cause coverage is a little bit different, and it actually includes not only the list of exceptions we saw for the rent control, but it adds that additionally, the people who are living in the unit have to have been living there for 12 consecutive months lawfully. A lease, and they had to be there for 12 months. But there's a wrinkle, and I just want you to see how fine the wrinkles can be. Let's say an adult tenant is added to the household at some point during those first 12 months. Then it actually means that you wouldn't be covered until everyone in the household has been there for 12 months, or at least one adult has been there for 24 months. Again, that can get confusing, but the point of me sharing this with you is so that you sort of see the extent of detail around some of these issues. And if ever you want to refer back to the slide, you can take a look at the specific requirements. Now, the good news is I wanted to start this presentation by saying there's a lot of bad news that we're hearing, and I'm here to deliver some good news. And this is some of the good news. We're seeing cities around the Bay Area adopt more protections for tenants. And in cities that I just would not have imagined this happen. So, for example, in Contra Costa County, the city of Concord adopted some additional protections for their renters. And so, for example, the categories of protections in all these three cities in Contra Costa County include stronger protections than the ones we just talked about from the state in the just cause and rent control category. Additionally, these protections include relocation payments. So if you receive a termination notice from your landlord saying, you need to leave, I'm terminating your lease for reasons that are not your fault, right? And we know that there's certain categories of reasons they can list. Then for those reasons, they would have to provide your relocation payment that is required under these particular rules, which are stronger than the state protections. Additionally, in each of these cities, Antioch, Concord, and Richmond, the cities have adopted protections to prevent landlords from harassing tenants, which is a new development that I've been very excited about. Certainly, we continue to see tenant harassment happening, but it's encouraging to see that there are cities who are concerned about displacement of tenants and they're adopting these additional protections to try to keep folks housed. Now, the reason I wanted to note that the City of Concord's just cause and rent control protections are new is yes, they're new, but there actually have been some developments as of recently where the City Council in Concord back in February voted to essentially weaken their protections. So they had adopted a certain set of rules that were, quite comparable to these other cities. And at the end of February, they said, okay, well, we're going to loosen these protections a little bit. And so they recently, the change was that for rent control, they were going to keep a flat rate of 5% rent increase limits, which is higher than what they initially had adopted. And then for just cause, they basically said, we want just cause to apply to every single family home. And when they voted to weaken the protections, they limited the types of single family homes that applied to. So I just want to let you know that if you're living in these cities or if you have clients who live in these cities, there are additional resources for them to turn to. It means that there are additional resources like rent programs where they can file rent petitions for unlawful rent increases or problems around repairs. And additionally, they can lean on some additional protections like relocation payments to help them if, for example, their tenancy is terminated. With all these things, again, if you have questions, doubts around a particular situation, it's always important you reach out to somebody who is familiar with these protections. So, at least in each of these cities, I've hyperlinked the websites for each rent program. So if you click on Antioch, and you will receive these slides, or you click on Richmond, you'll see it's blue and underlined. It'll take you directly to the rent program website that has a whole host of resources for tenants, information about how their protections work. These cities also provide trainings. So the City of Richmond provides ongoing trainings for landlords and tenants if there are ever questions around how the protections work. Some really helpful resources there. And it's hard for us to think about this, but I'm here to tell you that another protection tenants have is the eviction process. And that sounds wild saying it because I specialize in helping people through the eviction process. But the eviction process is a whole process that's required before a landlord can lawfully evict a tenant. And yes, that in itself is a protection because there's a whole host of things they have to do before they can force someone to leave. And there's some important developments here that I'm excited to tell you about. The first is we'll start with the fact that before a landlord can ask somebody to leave, right? Let's say a landlord is ending your lease and wants you to move out. They have to provide you a written notice. And that written notice, the requirements of what's required to be on there, are controlled by state law. And there could be multiple requirements about what it has to say, how much time you have to move out that depend on your particular situation, like where you live, how long you've lived there. But I'm here to tell you that why that's important is because you have no legal obligation to move out if your landlord sent you a text message or told you, hey, you need to move out by Friday, because the law says I need a notice, I need a certain amount of time, and then I need certain information before I have the legal obligation to move out. Now, if you do receive a notice, then once the notice expires, there's usually a number of days associated with the notice you receive, depending on the type of notice. Then that's when the landlord can file an eviction lawsuit and start the eviction process. When they file a lawsuit in court, the court requires that they provide you a copy of a summons and complaint for the eviction so that you know you're being called to court and why you're being called to court. We'll go through what that looks like in a couple of slides. But essentially, the key thing here is that once you receive those documents, and you can receive them in a couple of different ways, once you receive them, it's usually a packet, a very thick packet with a bunch of different pieces of paper, look like forms. They have the information of the court on them. But once you receive them, a tenant has 10 court days to respond. And that is big news because Since 1971, tenants had 5 days in the state of California to respond. And again, it's 5 days, and I'll clarify that's not going to include weekends and it's not going to include state court holidays. So you wouldn't count those days as part of the five or part of the 10. But this is big news because the state, as of this year, said we want tenants to have more days to be able to get help, to be able to prepare their forms and file a response with the court. And this is, again, some of the good news that I come with you. I'm tired of hearing the bad news. I'm here with good news for you. Um, and keep in mind that within those 10 days, it is important for tenants to get help so that they understand what requirements they have to fulfill to be able to defend themselves in this lawsuit. So the immediate thing is they have to file an answer, which is a form, with the court before those 10 days are up. Now, once that happens, let's say they file an answer with the court, then the landlord can request that the court set a hearing date or a trial date. And then once the court receives that, they'll usually set that date within 21 days. So this is a process that moves fairly quickly, but again, it's a process that's required before a landlord can force you out. They actually need a court order before they can ask you to move out of their home. And these are some examples of notices. I know that a lot of you are service providers that may have clients who come to you with documents. And I want you to sort of be aware that some of the notices that they may get are legal documents that require certain things happen. So it could be that they receive a 30-day notice, a 60-day notice. In some cases, it could be a 90-day notice. It is very common to see 3-day notices to quit or 3-day notices to pay rent or quit. And what is on these notices can vary, and what the legal requirements for them can vary too, depending on, like I said, where a tenant lives, how long they've lived there, and what the underlying issue might be. So whenever you see anything that on the title says, notice to vacate, notice to quit, and it has numbers on it, 330, it is important that you connect a tenant to resources so they can get legal advice to understand, okay, what are my rights when I get this notice? What things do I have to do? And what can this mean depending on the situation that they're living in? And we talked about, excuse me, I'm just been a little bit sick. But we talked about a summons and complaints. So once the eviction lawsuit is filed, the court is required that requires the landlord to give you a copy of the documents. And the summons, which you can see here on the left-hand side, tells you that you're being called to court, and it looks like this. I want to point some important things out to you on these notices. You can see that there's lots of tiny writing that can be really difficult to read. But on one side, it tells you you have been sued, and it tells you you have 10 days, not counting Saturdays, Sundays, and other judicial holidays, to file a written response with the court. Now, that's really important because a lot of times when folks receive these documents, they get very overwhelmed and they don't read them. But actually, reading them will tell you some really important information on there. It also directs you to some additional resources to get help. Now, on the right side of this summons form, you'll see that it's in Spanish. So this appears in both English and Spanish. If you ever see clients or folks, or if you yourself ever receive one, I do recommend you do your best to go through them to see if there's any important information you can get just by looking at it. Certainly, it is important that folks see that there is some really important information, just it's buried in tiny print. Now, the second part that you'll receive, and this isn't the only sets of documents you'll receive, these are just sort of the cover pages of the things you'll receive, is the complaint. This is the first page of the complaint, and this is what it'll look like. It'll have a whole host of important information on here, like who the party is who is suing you. And it could maybe be that they're being represented by an attorney, and you'll see their information. It'll have the court address of where you're being sued. and the case number so that you have sort of this essential information about where am I being sued, who's suing me, and the complaint is going to go through why you're being sued. So if it's based on, let's say you didn't pay your rent, there should be a notice that's included on here that you should have already received telling you that you've missed a payment of rent. But I just want you to see generally what these first pages of these forms look like in case you see these in the service of what you do, and you know that once you see these, this means that folks have 10 days to file an answer, and there's specific steps they have to take. So it's important they get help to complete those additional steps. The really the danger about failing to file a response here is that if you miss these 10 days, let's say you don't file a response and you just ignore this or just don't know what to do, you get overwhelmed, whatever the case might be, then that means that the landlord can go to the court and say, listen, the 10 days have passed. I'm asking for an automatic decision to evict this tenant. And that would mean that you would have played no part in asserting any defenses that you have or telling your story or trying to negotiate a resolution. You would automatically be evicted. And there would be an automatic decision that the sheriff could come out and post a notice to enforce. And so the danger really is that you could automatically be evicted if you don't file an answer or attend your hearing. Now, in a time, let's say in a trying time, I think it's important for us to think about what protections we have related to housing discrimination. I think it's really important for all of us to know that there are protections, there are state and federal protections that essentially prevent discrimination in housing by making it illegal to disadvantage someone in renting, buying, or occupying a home because of that person's membership in a protected class. And we're going to go and we're going to talk about what a protected class is, who is protected, what does that mean? And I just want to list here the sources of the different laws that cover these protections. So there's federal laws that prevent discrimination, and I've listed some here. And then there's also state laws that prevent discrimination or make it illegal. Under federal law, and I want you to imagine that federal law kind of establishes a baseline, right? They basically say these are the baseline things that we absolutely prohibit discrimination on. And then the state, whichever state you live in, they can add additional categories on top of those to provide even more protections. So the ones that exist under federal law, race, color, religion, sex, familial status, national origin, and disability. Now, California law also includes some additional protections that include a whole host of other things, including significantly veteran status, immigration status, gender expression, and most recently, source of income. Now, I've hyperlinked a couple of things here that I just want to point out to you in the slides. So if you click on the part that says protected classes, it'll take you to the California Department, um, uh, I'm sorry, Civil Rights Department of California. They just recently changed their name to CRD. It used to be DFEH. But essentially, they're tasked with enforcing these rules, and they have a really helpful website where they provide all kinds of interesting information. And in this case, you could go directly to their housing protections, and it lists out all of these protected classes and then additional resources for each one, like fact sheets. I'm including one fact sheet here for immigration status. That's really interesting because it covers a whole host of things, not just housing. And it talks about examples of what that discrimination can look like and how, by identifying that type of discrimination, people can report it or file complaints with the state for it. And I'll go into a little bit more detail about that, share some examples, but I just want you to see these additional resources in case you want to do some exploring of your own around additional resources. Now, one topic, let's say that I want to delve a little deeper into is that As we talked about, disability is a protected class that essentially people providing housing are prohibited from discriminating against someone because they have a disability. But there are some additional rights to help folks who have disabilities enjoy their housing to the fullest. And one thing that can be really helpful to understand is that people with disabilities are entitled, can, under the law, request what's called a reasonable accommodation or a reasonable modification. I'm really going to just focus on reasonable accommodations, but essentially what that is it's a request to change a rule, a policy, practice, or a service that's going to be necessary to allow someone to enjoy their housing. And the request itself, we're going to go through what are some of the best practices to make that request, what type of request is that, and what's required. Generally speaking, I do want you to see that both of, let's say, the federal rules and California rules define what a disability is, like who is eligible based on what a disability is. The federal law requires that whatever mental or physical impairment substantially limit one or more life activities, or that they have a history of such an impairment, or that they are regarding as having such an impairment. I want to let you know that California doesn't have quite that limit. It's actually a little bit more inclusive. It just says that it has to, the the impairment has to limit your, I forget what the language is, limit your life activity. It doesn't require that it be substantial. And that just means that if you have a disability, let's say a disability need or medical need, you can request for your housing provider to make a rule, to make a change to a rule or practice, so long as that rule or practice is related to the request that you're making. Now, what's a common example of this? I can tell you that there are many common examples I see in my day-to-day work. One very common example is, let's say you are assigned a parking spot and you have some mobility issues related to your disability, mean that you require a parking spot to be closer to your unit, not even necessarily a handicap spot, but maybe just a spot that's directly near your unit to be able to access going in and out of your unit. You could make a request where you say, "Dear landlord, I am asking that you assign me a parking space because I have a mobility issue related to my disability that requires that I have easier access to my unit." Now, you see there that the request is directly related to a disability need that you have, and that's the essential part of making the request here. And that's what we call a nexus. So your request has to have a very clear link between those two needs, the request that you're making and the need that you have. Some of the best practices that we recommend, it is important that you know that there is no requirement under federal law or California law that have a certain form. So it doesn't say, like, federal law doesn't say you have to provide this form in order to meet this request, or it has to be in writing. You could actually make it orally, and that would be just as valid as one in writing. But as you know, I would recommend you make it in writing because you want to have a record that you're making this request if there's ever a dispute in the future. Like, let's say your management changes and they say, "Oh, well, we never received that request." If you have a copy, you can say, "Okay, we understand, but here's a copy of the request that I made." So it is always important to keep a copy of whatever request you're making. And additionally, maybe that the landlord asks you for verification. Now, that verification is only required if, let's say, your disability is not apparent. So if it's not a readily apparent thing, they can require some verification, but the verification doesn't have to have absolute detail of everything you're experiencing, what your diagnosis is. It could be a letter from a doctor or even another professional that says they require this accommodation because of a disability need that they have. So it can be carefully crafted to limit the information that's shared, enough to provide some supporting documentation. If ever there's questions around that, again, I certainly recommend You seek out providers that have the expertise to be able to guide you through, okay, what is required, what is not required, what can you do if you're concerned about your medical privacy. And then I want to talk about um, the additional protections around immigration status that exist in California. And these things I think are lesser known. When I've been out to presentations and been a part of community events, I see less and less information about these protections. So I want to make sure you see them in case they can be helpful to you, folks you know. California adopted what was called AB 299 that made some modifications to some existing rules in California. And part of the modifications essentially provided that landlords are prohibited in the state of California from asking a tenant about their immigration or citizenship status unless they're having to comply with the federal program. And so, to give you an example, if you are applying for subsidized housing, let's say public housing, federal rules require that you have a certain immigration status, and therefore your housing provider, let's say the housing authority, could ask you about your immigration status. But generally speaking, if there is no federal program that requires citizenship tied to a subsidy, they don't have a right to ask you about that, and it's certainly not required. They can't require a tenant or even a prospective one if you're just applying to make a statement or provide certification about what their immigration status is. An important part here is that they are prohibited from disclosing any information relating to the immigration status of a tenant or perceived immigration status of a tenant for the purposes of harassing them, intimidating them, for purposes of forcing them to move out, for retaliating them, or trying to recover the possession of the unit. That in itself, so any of these things, asking a tenant about their immigration status, disclosing any information to harass them. Let's say they're saying you're illegal, I'm reporting you to ICE. That under these rules is considered housing discrimination. And so I do want you to be aware that there are additional protections in the state of California that are stronger than the federal protections that can provide additional safeguards for folks in our community. And certainly, thing to consider when you're thinking about the whole scale of the protections is, well, what do you do when you think discrimination has happened or when you've experienced discrimination? There's a couple of things that folks can do. Certainly, the law provides under federal law and state law that you can file a housing discrimination complaint. And what that means is the federal government and the state government in California have created agencies that handle these complaints. And so HUD has one, and then the Civil Rights Department for California has a department. And they receive complaints in a number of different ways. I've hyperlinked here. So if you click on this, HUD and CRD, it'll take you to their complaint pages. And you can file them a couple different ways. You can file them online. They have paper forms you can fill out. You can even call and file a complaint. And essentially what happens is you would file a complaint based on an act of discrimination or multiple acts, and then it would be assigned to an investigator who would investigate it. Through the process, it may be the case that they invite both parties to mediate or try to resolve their issue. If they're not able to resolve the issue, then they may issue a finding as to whether they believe there is discrimination or not. But then would allow you to figure out, okay, do I want to pursue this further? Do I want to sue them with that finding of discrimination? Now, what's interesting is that in housing law, compared to employment law, you don't have to go through this process. So again, in housing law, you don't have to file a complaint to file a civil lawsuit. You could just go straight to filing a civil lawsuit for damages, and an injunction is asking a court to prevent someone from doing something. So stopping the discrimination or stopping some behavior. So that's important to know because with employment law, you actually do have to go to a complaint process before you file a lawsuit. But with housing, you could just go straight to filing a civil lawsuit. And then additionally, it's important to consider that discrimination, whether it's under federal law or state law, is a defense in an unlawful detainer eviction. So let's say you requested a reasonable accommodation and your reasonable accommodation was denied, and it was denied for reasons that are not permitted. Then that actually is considered housing discrimination, and you could raise that in your eviction lawsuit as a defense. So there are a couple of different ways to enforce these protections. I certainly encourage folks to navigate these websites, the HUD website, the CRD website, to see all of the information I have on there about programs, about resources, trainings even that folks do. The Civil Rights Department in California does a monthly training series through their outreach department that I highly recommend for folks. They're really knowledgeable staff. I'll generally say that given sort of the cuts that are happening across HUD, my recommendation would be that if folks can, they should try to file any complaints with CRD in case maybe HUD is vastly understaffed at the moment. Um, and with that, I wanted to go through those things and leave time for questions. So I'm going to turn to questions now, and let me see if I can open the chat to see if we have any questions that folks have asked, and give me a second to go through these. Let's see, Greg says, as for the cleaning fee, if the tenant returned it in a clean condition, can the landlord still charge for that? It's a really good question. I mean, I think there's an argument on the one hand that if they don't need to additionally clean, because there are some tenants who themselves are expert cleaners, that they may not need to charge additionally for that. Now, if it's a situation where there's a particular process they have to follow, like let's say the lease outlines that there will be a cleaning fee for some sort of standard that management has for cleaning, then it may be something that they may be able to charge. So it would be really fact specific. Again, what I would recommend is folks take pictures of the condition they left the unit in case they want to dispute any additional fees if they're thinking it's not reasonable because we left the unit in impeccable condition. That's certainly what I would recommend. And then Kimberly says, is a 60-day notice to vacate the same as an unlawful detainer? That's a really good question. So no, so a 60-day notice is just a notice that is going to terminate your tenancy. So in theory, you have 60 days to potentially leave your unit. And at that point, there's no eviction lawsuit that can be filed. Certainly, it shouldn't be filed. It's not permitted under the law. What it does is it's just giving you essentially a heads up that's required by law to potentially move out. But I do recommend that because it is a legal notice that has certain requirements, that folks get legal advice to understand, okay, is this a valid notice? Do I have any legal rights related to this notice as they're trying to make decisions around, leaving or moving or what comes next? Now, when does it become an unlawful detainer? So I want you to imagine a lawful detainer is an eviction lawsuit, and it becomes an eviction lawsuit once the eviction lawsuit is filed with the court. And at this point in time, let's say we have a 60-day notice, that cannot be filed until after the 60-day notice expires. So it wouldn't be an eviction until that notice expires and the landlord files an eviction lawsuit. And let me know, Kimberly, if that makes sense. Certainly it gets confusing because there's so many different types of notices. Um, I guess another way to think about it is a 60-day notice would not require that you file an answer within 10 days. Whereas if you get the eviction lawsuit paperwork, the summons and complaint, you would be required to file an answer within 10 days with the court. And then a next question I see here, if a landlord has a habitable unit, will they still need to follow these steps by filling out a court order? And Kimberly, are you able to come off mute and explain your question a little bit better? Just want to have a little bit more information, make sure I understand. Certainly encourage you, if you want to put it in the chat, please feel free to put it in the chat. Um, and then Kimberly, I see another question, even if it's an add-on to the property. So please let me know if you're able to come off mute, if you want to clarify your question just a little bit more. It may have been that you were responding to a particular section that I was presenting on. Um, Yeah, so Kimberly, thank you for adding some a different Kimberly, Kimberly Krish, thank you for adding some additional responses here. You were wondering if a tenant has to file a response to a 60-day notice. Yeah, and that's exactly right. They don't have to file a response to a 60-day notice, but they would have to file a response to the summons and complaint. The difference would be that there would be court information on the summons and complaint.
Hello? Can everyone hear me now?
Yes.
Oh, yes. My question is, this is a very common practice in Contra Costa County where um landlords have properties and then they have like they built an add-on. Let's
Mhm.
say like in the backyard they'll have like a the best way to describe this is like a tiny house.
Yeah, I'm familiar. Yep.
Um, will they still need to follow this process of like um giving them a notice and then like taking it back to the courts or fight?
Absolutely.
Okay.
Yes. And so that's a really good question, Kimberly. And the reason why it's a really good question is because the the question that I'm also hearing and what you're saying is who gets these protections of this process of having to file a lawsuit in court? Who gets those protections, right? And that's a really good question because the way that the law defines it is tenants get those protections. And the way that we think about tenants is tenants are people who have an agreement to rent a space. And I'm here to tell you that an agreement can be oral or it can be written. So if a tenant lives in an ADU or a little house or even a garage, let's say, which is very common where we live in Richmond, where I live in Richmond, if that tenant is paying rent, and let's say they have an oral agreement to pay rent, the act of paying rent and the other person receiving it means that they have formed a tenancy and therefore they're a tenant, which means that they're entitled to these additional rights. Like, where would you not be entitled to those rights? So, if you were a trespasser, let's say you found a home, you broke into the home, and you're living in the home, because you don't have permission to be there, there's no exchange of rent, then a tenant, I'm sorry, a landlord doesn't have the obligation to follow these additional protections and let's say file a lawsuit. So, Camilla, that's a really important question that for us is the distinction between being a tenant and not being a tenant. So, the people who are tenants who pay rent, whether it's through an oral contract or written, have these protections. So, that would apply to, for example, a tiny home or anything like that.
Okay.
Yeah,
Thank you. I
yeah, really
appreciate
good
that.
question. Did you want to add anything to the other? Oh, I see. It was the same. It was the you were explaining. Gotcha, gotcha. And then let's see. There's some additional questions. Give me a sec to go through them. Is a 60-day notice filed in the court if it came from an attorney? So a 60-day notice doesn't have to come from an attorney in order for it to get filed with the court. It can come from a landlord who's not represented. And once that notice expires, that unrepresented landlord who doesn't have an attorney can file an eviction lawsuit. So there's no requirement that the notice itself come from an attorney. It can be valid even without an attorney. Certainly, what I do see is that there can be a lot of issues with notices that don't come from attorneys because, let's say, the landlord may not be familiar with what's required to be on the notice. And seeing some other questions, is there anything important to know for individuals needing to move out and end of lease due to DV, IPV? Yeah, so there, Francine, that's a wonderful question. There are lots of things. What I'll say is there are a whole host of protections for people experiencing domestic violence. Um, and really, I would say that's an entire presentation because there are state protections and federal protections that can apply. I'll say the most important one that comes to mind is that under state law, um, also under federal law, but let's talk about state law. There is an early lease termination permission or I won't say permission, so a right to terminate your lease early. So let's say you're experiencing domestic violence and you still have a lease, a year lease or something. Normally it's really hard to break a lease, but if you want to break a lease under these situations, let's say domestic violence, the state says that you can terminate your lease with a 14-day notice. And that 14-day notice has some additional requirements. You can attach with that 14-day notice verification of the domestic violence, which can take a couple of different forms. Certainly, the key takeaway there is that once you provide that notice, you can move out, but it allows you to terminate the lease without having to be responsible for additional rent that they can charge you for terminating your lease early. But yeah, please let staff at Family Justice Institute know if you're interested in presentations around protections related to domestic violence survivors, IPV in housing. Because yeah, that's a whole presentation with lots of interesting information.
Okay, thank you.
Yeah, absolutely. And the great thing about that is there are lots of resources. So if we're looking for, let's say, the 14-day notice that you have to give your landlord, there are organizations that have sample templates. And I can certainly try to share that out with staff to share out to you when the PowerPoint goes out. And then, I'm sorry, just catching up to all the new ones. From Kimberly, what is tenant to do if he has been prevented access to items, asked for a key multiple times, brushed off? Um, so maybe that's a situation where a tenant shares let's say, home with the landlord, and they're sharing things like bathrooms and kitchens. Um, those situations can be really difficult because it depends on what the agreement was initially. So if the agreement was by paying rent, you have access to the bathroom, the kitchen, then that landlord can't prevent access. But certainly that gets complicated when there's no agreement, and there's conflict. So that can be, right, that can be very difficult. But in theory, they should have access to sort of the essential things that make a unit habitable, right? Which we talked about before, which would be like they would be required to have access to a bathroom. They would be required to have access to certain facilities, water, gas, things like that. Um, I'm trying to keep up with your questions, so give me just a sec to see. Um, Our adult school has curriculum about housing rights for English language learners. Okay to share this PowerPoint with the teachers who are teaching the curriculum? Yes, absolutely. Please feel free to share this presentation as helpful. Certainly, I want you to see it as a resource and keep in mind that it's not comprehensive, right? So there are new things and other issues, like, for example, protections for domestic violence survivors that are not on here, but certainly to the extent that it can be helpful, please feel free to use it. Yes, you will be emailed the PowerPoint afterwards. And I'm sorry, I'm also seeing, Kimberly, you're asking about a particular situation about a common law marriage where there's no agreement in place. And tenants being told about access to a room. I would certainly recommend that they reach out to get legal advice from any organization that can specialize in some of these issues. So in Kimberly, are they in Contra Costa County, or are they in another county? They're in Martinez. Okay, yeah. So I would recommend either Centro Legal de la Raza or Bay Area Legal Aid, and we provided our information here for them to just call to get uh, legal advice, and you're saying they're a person with disabilities, mental and physical. So our legal advice line allows for a third party to call so long as they have like oral permission from the affected person to speak with them. So what they could do is they could call with like a social worker or a trusted relative if they want some additional assistance. Yeah, so again, Kimberly, I would recommend they reach out to someone to get legal advice about their particular situation. Um, and I'm sorry, I'm seeing that there's a security deposit question that I'd like to answer. Give me just one moment because the chat keeps updating. Um, Regarding security deposit, does this mean landlord can only charge first and last month's rent, no separate security deposit? Um, So what it means is that in terms of the security deposit, they can only charge 1 month's worth of rent unless it fits in the category that we saw the exception where they can charge up to 2 months rent. So that now means that it can only be 1 month's worth of rent. Yeah, and so with that all, I'd love to give you back some of your time on a Friday. You were very patient in us starting the presentation. At our start. I thank you so much for your time and your learning. And if, again, you have any questions, you will have the slides to be able to